Hi, good morning, everyone. I just wanted to check what have we covered in the last. Have we done with 30? We're done with it. Okay, fine. So now the last important provision, which is there in the chapter of part 3 of fundamental rights, is Article 32 of the Indian Constitution, and Dr. B.R. Ambedkar says that this is the very heart and the very soul of the Indian Constitution, and the reason for that is he says that because fundamental rights, if they are not enforceable, if a citizen does not have a remedy in case a fundamental right gets violated, to approach the court and to ask for the enforcement of a fundamental right, then fundamental rights lose all their meaning. So it's important that the fundamental right should be enforceable in nature. One can approach the court and ask for their enforceability. But what is important here is that this right would again remain to be a mere promise if one had to go through the rigors of the Indian judicial system. Because if one had to go through the appeal mechanism from the lower court to the high courts and from the high courts to the Supreme Court in order to get a remedy in case of violation of fundamental rights, it would become a torture in itself to ensure the enforcement of the fundamental rights, because we know how the criminal justice system and the judicial system functions in India. So therefore, the Constitution of India says that not only will the right to approach the courts in case of violation of fundamental rights be a fundamental right itself, but also a citizen can approach the Supreme Court of India directly for the enforcement of fundamental rights. And this itself is a fundamental right which has been guaranteed by the Indian Constitution. So Article 32 of the Indian Constitution is providing a right to all the persons in India to approach the Supreme Court of India through an appropriate procedure to ask for the enforcement or a remedy in case a fundamental right is violated by the state or by some other individual, as the case may be. So Article 32 therefore becomes a very important provision that ensures the enforcement of the fundamental rights and ensures that they do not remain as mere promises or puff birds that have been mentioned in the Indian Constitution. But what you need to also keep in mind is that we don't have just Article 32 of the Indian Constitution for the enforcement of the rights. Article 226 of the Indian Constitution also provides a right to people to approach the high courts in India for the enforcement of fundamental rights as well as for other purposes. That basically means if there is some legal or statutory right which is getting violated, then in that case a person can approach the high court as well for the enforcement of that particular right apart from fundamental rights. Citizens have options of approaching both the Supreme Court and the High Court, of course, depending upon where the cause of action lies, where the matter originated, one would approach the Supreme Court or the High Court, and it has happened in the recent past as well, where when people have approached the Supreme Court of India, they have been told to approach the High Court first for the enforcement of the fundamental right, and if they do not get the appropriate relief, then they can approach the Supreme Court through an appropriate appeal mechanism against the decision of a High Court. So we have powers that have been provided to the Supreme Court as well as to the High Courts in India for the enforcement of rights. Supreme Court has been provided that right under Article 32. High Courts have been provided that right under provided that power under Article 226. Supreme Court has the powers to enforce only the fundamental rights, whereas High Courts have powers to ensure the enforcement of all the rights, including the fundamental rights, which may include even other ordinary or statutory rights that may have been provided by an ordinary law. And what we also need to keep in mind is that Supreme Court can entertain cases from the entire country when it comes to violation of fundamental rights. Anywhere in the country, if a violation of fundamental right takes place, a person can approach the Supreme Court of India directly. Whereas when it comes to the high courts in India, they can entertain cases only from the territory which is under their defined jurisdiction. So, even though the scope of the exercise of powers with respect to the rights of high courts is broader than the Supreme Court when it comes to the types of rights, but it is narrower as compared to the Supreme Court when it comes to the area of jurisdiction. That is what we need to keep in mind about Article 32 and 226, which we'll have more detailed discussion on. The other thing which you also need to keep in mind is that once a person approaches the court and says that there has been a violation of a fundamental right or there has been a violation of a right, then what can the court do? Court can issue an appropriate order as it may consider fit in order to provide some kind of a remedy in that case. Now, these orders which are issued for the enforcement of the rights are called as writs. So, court issues what is called as writs in order to ensure the enforcement of the rights, whether fundamental rights or the other rights. And in the Constitution, in Article 32 and 226, specific kinds of writs have been mentioned, which can be issued in specific situations. There is a writ of habeas corpus, which is usually issued in the cases where there is an illegal detention or an arrest of a person that has taken place, not as per the law. Similarly, the court also has powers to issue the writ of mandamus, which essentially gives powers to the court to direct a administrative authority or a court to do something because of whose inaction a fundamental right of some person is getting violated. Then there is a writ of quo warranto, which basically asks which provides court the power to ask those who are in the public office to show their warrant of appointment, that is to ensure that anyone who is occupying the public office should not be doing so in an illegal manner. And then we have the writ of prohibition and certiorari, which is issued by the courts to lower courts or to tribunals in order to ensure that they do not exceed their jurisdiction or there is no gross miscarriage of justice that is happening to any person by the functioning of these particular lower courts. So we will discuss about these writs in detail, but let's first discuss about Article 32 of the Indian Constitution now. So Article 32 of the Indian Constitution has 4 clauses. The first clause of Article 32 of the Indian Constitution says that the right to move the Supreme Court. बोलो सर. सर पहले 32 पढ़ लें, मेरे को भी पता है 31 पढ़ना है, पढ़ लेंगे सर उसको भी, है ना. ऐसा तो नहीं है कि मुझे कॉन्स्टिट्यूशन मेरे को गिनती नहीं आती कि 30 के बाद 31 आता है. पढ़ लेंगे सर, पढ़ लेंगे. तो ऐसी कोई प्रेसिंग नीड नहीं थी कि मैं अभी एक चीज पढ़ा रहा हूं, आप उसके अंदर मेरे को बोलें कि सर 31 का क्या हुआ, है ना. मैंने बहुत सारी चीजें नहीं कवर करी हैं सर, है ना. 32. सो द राइट टू मूव द सुप्रीम कोर्ट by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. So, the right of a person to move the Supreme Court for the enforcement of the rights that have been mentioned in Part 3 of the Indian Constitution is guaranteed. Now, we have already discussed about the meaning of the term guaranteed, right? And in this particular Article 32 clause 1, it is saying that this right to move the Supreme Court for the enforcement of the rights conferred by this part is guaranteed. Now when it says is guaranteed, it means that this itself is a fundamental right which has been provided to the people in India. And it is very important as well, because if this would not have been a fundamental right, then probably this right could have been curtailed by the state by making a law. But you do not want that the enforcement of the fundamental right should suffer. Otherwise, what is the point of having fundamental rights? So enforcement of fundamental rights is in fact even more important than the fundamental rights itself. Therefore, Article 32 itself is a fundamental right. And how can we say that? Because it is saying that the right under this particular article to approach the Supreme Court is itself a guaranteed fundamental right. It's a guaranteed right. That means it is a fundamental right which has been given by the Indian Constitution, and all the safeguards that are applicable to the fundamental rights would be applicable to the right under Article 32 of the Indian Constitution as well. Right? Also, the meaning of the term is guaranteed is that the court is duty bound to provide relief to a person where the court finds that prima facie there has been a violation of a fundamental right. So the meaning of the term is guaranteed is that it is itself a fundamental right, and the second meaning of that term also is that this right itself, not just it's a fundamental right, but the Supreme Court is duty bound to provide a remedy in case of violation of a fundamental right. If Supreme Court finds that there is a violation of fundamental right, it has to provide a remedy. There is no escape from that. Though one may ask that what kind of remedy will be provided by court, that's discretion of the court. You can't ask for a specific remedy to be provided to you in case of violation of fundamental rights. That's not your right. Your right is to approach the Supreme Court and ask the court for the enforcement of the right in case it has been violated. Now, you cannot ask the court that I want this specific relief because of violation of the fundamental right. Though court cannot refuse you any relief, but what relief would be guaranteed or would be provided by the court is something which is completely a prerogative or discretion of the Supreme Court itself. The other thing which has been mentioned in Article 32 of the Indian Constitution, Clause 1, is that one has right to move the Supreme Court by appropriate proceedings. Now, when we read the term appropriate proceedings, ideally, it should raise a question in our mind that is it trying to talk about some specific kind of format or some prescribed form in which one needs to approach the court for asking for the enforcement of fundamental rights. That is there a prescribed format that you have to fill your application only in that particular format and then you need to approach the court? The court says that no. Appropriate proceedings as a term has been provided widest possible interpretation by the court. Because the court says that for mere technical reasons, if a person is not guaranteed a fundamental right or is not allowed the enforcement of a fundamental right, let's say someone's fundamental right has been violated and there is a prescribed format in which you need to approach the court through under the meaning of the term appropriate proceedings. But let's say you are an illiterate person or you are someone who does not know the legal proceedings properly, then does it mean that you should not get the right? Of course not. So it says that through appropriate proceedings, but the court says that we will not let technicalities come in the way of the enforcement of fundamental rights of the people. Appropriate proceedings mean that any way in which you approach the court, which is for the enforcement of a right, will be considered as an appropriate proceeding. It does not matter whether you approach the court by writing on a postcard, whether you approach the court by writing a WhatsApp message or an email or a mail, it does not matter. And there is no prescribed format, because हम इसको एक रीजन नहीं बनने देंगे कि आप स्पेसिफिकली ये फॉर्मेट फॉलो करेंगे तभी हम आपको राइट देंगे. You can approach the Supreme Court of India as long as there has been a violation of a fundamental right. And that is all what court will be concerned about. Whether you have approached in an appropriate format or not does not really matter. So, Supreme Court of India during the late 1970s, Justice P.N. Bhagwati, Justice V. Krishna Iyer said that a person can approach the Supreme Court of India even on a postcard. At that point of time, only the postcards used to exist as the cheapest means of communication that were available to the people. 15 paise ka postcard aata tha. So you could write on a postcard and approach the Supreme Court of India, any of the judges, if there has been a violation of your fundamental rights, and on receiving such a postcard, on receiving such a letter, if any of the judges of the Supreme Court is satisfied that there has been a violation of a fundamental right, then they will provide you a remedy in that particular case. So that is how Article 32 has been given the broadest possible interpretation by the Supreme Court of India in order to ensure the effective enforcement of fundamental rights in the country. Now, the other thing which we also need to keep in mind is Article 32 Clause 2. That is, what remedies will be provided or what kind of action will be taken by the court in case the fundamental right is getting violated. So Article 32 Clause 2 says that the Supreme Court shall have powers to issue directions or orders or writs. Okay, so Supreme Court, with respect to the enforcement of the fundamental right, when a person approaches them, has powers to issue orders, directions or writs. Writs are nothing but these are orders which are made specifically for enforcement of rights. So these are specific kind of orders which are made by the court, which are for the enforcement of rights, not just fundamental rights, but for rights, because writs are available even to the high courts in cases of the violation of other rights as well, other than the fundamental rights. So the court can issue writs for the enforcement of the rights, and then it specifically mentions a few writs which are available to the courts, which they can issue for enforcement of fundamental rights. But that does not mean that these are the only writs which they can issue. This is an example or a list of writs which have been provided, but it's not just restricted to these writs. But what are these writs which have been specifically mentioned in the Constitution? It says that including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate. अब आप कोर्ट को यह भी नहीं बोल सकते कि सर आप ये वाली रिट इशू कीजिए, ये कोर्ट के ऊपर है कि वो कौन सी रिट इशू करेगा, डिपेंडिंग अपॉन whichever is the appropriate writ, because each one of these writs or orders which are issued by the court are for a specific purpose in specific conditions. आप habeas corpus की रिट उन केसेस में इशू नहीं कर सकते जहां पे the authorities have failed to act, and as a result of failure of their action your fundamental right has been violated, right? So specific purpose के लिए specific writ issue की जाती है, and you cannot ask the court that which writ should be issued. The court will decide that which writ has to be issued, as it says that whichever may be appropriate for the enforcement of any of the rights conferred by any of this by this part. Now please compare the text of Article 32 once with Article 226 and tell me, do you find any other difference apart from what we have discussed? That is, the writ of the High Court is applicable only in their area of jurisdiction. Writ of the Supreme Court is applicable in case of the entire country. Writ of the High Court is applicable not just for fundamental rights but for the other purposes as well, whereas writ of the Supreme Court is available only in cases of fundamental rights. Other than these two differences, is there any difference between the writ power of the Supreme Court and the writ power of the High Courts in India? If you can tell me any difference that you see between Article 32 and Article 226. It's a very minute difference but a very important difference. Yes, anyone who can tell me? Sorry? What do you mean by that? Can you explain that a bit more? How are you able to say that? Sorry, yeah. So you're right, but how do you say that? On what basis are you saying that Supreme Court is duty bound and High Court is not duty bound to issue any kind of a writ with respect to enforcement of a right? वो तो ठीक है, वो तो हम डिस्कस कर ही रहे हैं, बट व्हाट शी सेड that high courts are not duty bound to provide any kind of a remedy in case of violation of a fundamental right, in case of violation of a right, but Supreme Court is duty bound. She's correct. But I want to know what is the reason for that. Exactly. अरे fundamental right कैसे? Because the word is guaranteed is not mentioned in Article 226. भाई लीगल तरीके से सोचिए, है ना? जस्ट डोंट से कि ये ऐसा है, वो तो पता ही है फंडामेंटल राइट है, बट क्यों है? Why is the Supreme Court of India duty bound and high courts are not duty bound to provide a relief in case of violation of a right? Because in Article 32 it says that it is guaranteed. So what she said is absolutely correct. But the reason is that the word is guaranteed. The term is guaranteed has not been mentioned in case of Article 226 of the Indian Constitution. समझ में आ गई बात, right? So first and foremost, a couple of things which we need to understand here, that what do we mean by the term appropriate proceedings? So the term appropriate proceedings has been given the most liberal interpretation by the courts in India. The meaning of the word appropriate proceedings, the court says, does not refer to any form or format, but to the purpose of the proceedings. As long as you are approaching the court for enforcement of a right or a fundamental right, in case of Article 32, as long as you are approaching the court for enforcement of a fundamental right, it will be considered as an appropriate proceeding. Do you get that? It does not matter whether you have approached the court on a postcard or whether you have approached the court through a WhatsApp message or through a mail or through a call. As long as you have been able to bring it to the cognizance of the court that there has been a violation of a fundamental right, and prima facie you have been able to establish that to the court has to provide you a remedy. What remedy? That will be discretion of the court, right? So appropriate proceedings as a term has been provided the most liberal interpretation by the courts in India. And the second thing is that what is the meaning of the term is guaranteed, which we have already discussed. The meaning of the term is guaranteed is that the right to move the court for the enforcement of the fundamental right is itself a fundamental right, and it is Supreme Court's duty to provide relief, and this does not mean that the court should provide a specific remedy. And Supreme Court can be the first court of instance in case of violation of a fundamental right. Now this is a very powerful provision because you can bypass the entire judicial system. In normal circumstances, it may take you years to approach the Supreme Court of India because you would have to first go to the trial court, then against the decision of the trial court, you would go to the High Court, then against the decision of the High Court, you would go to the Supreme Court. And it's not necessary that in normal proceedings, you may be able to approach the Supreme Court. ऐसा हो सकता है कि Supreme Court आपकी अपील ही accept ना करे against the decision of the lower court. In normal cases, it is possible that आप ट्रायल कोर्ट के डिसीजन के खिलाफ अगर हाई कोर्ट जाओगे तो हाई कोर्ट आपकी अपील ही एक्सेप्ट नहीं करे. बट इन केसेस में आप सीधा पूरे सिस्टम को बाईपास करते हुए सुप्रीम कोर्ट के पास जा सकते हैं, हाईएस्ट कोर्ट इन द कंट्री, the most powerful court in the country. So that is what is the significance of Article 32 of the Indian Constitution. And the other thing, of course, which we need to keep in mind is that Article 32 also provides specific writ powers to the courts in India. Same writs have been provided, writ powers have been provided to the high courts as well under Article 226. So we will discuss each one of those writ powers specifically. तो जल्दी से पहले एक बार Article 32 के बेसिक्स के ऊपर लिख लीजिएगा with respect to whatever basic introduction that has to be mentioned when it comes to the Article 32 of the Indian Constitution. So please write down Article 32. Article 32 of the Constitution has been mentioned as the very heart, has been mentioned as the very heart and the very soul, has been mentioned as the very heart and the very soul of the Indian Constitution, by Dr. B.R. Ambedkar. by Dr. B.R. Ambedkar. The reason for that is because fundamental rights would remain to be mere promises. Is that fundamental rights would remain to be mere promises. In absence of right of a citizen, to approach the court for their enforcement. Article 32 clause 1 mentions that Article 32 clause 1 mentions that the right to move the Supreme Court in case of violation of a fundamental right, the right to move the Supreme Court in case of violation of a fundamental right is itself a fundamental right. Full stop. The importance of this right can be understood from the perspective that one can bypass the entire judicial system and approach the Supreme Court directly. This article also makes the Supreme Court duty bound. To provide a relief if violation of a fundamental right has been established. The Supreme Court in Minerva Mills versus Union of India, L. Chandra Kumar versus Union of India, Minerva Mills versus Union of India, L. Chandra Kumar versus Union of India, and several other important cases has held that Article 32 is a part of the basic structure of the Constitution. और आगे फिर ये लिख लीजिए, that the term appropriate proceedings mentioned in 32 clause 1, the term appropriate proceedings mentioned in article 32 clause 1 has been provided broadest possible interpretation, has been provided broadest possible interpretation by the court. A person can approach the court. A person can approach the court in any manner, as long as the purpose, is to ensure, the enforcement of, fundamental rights. As long as the purpose is to ensure the enforcement of the fundamental rights. Is that clear to everyone? Please read whatever you have written just now. Very simple things, whatever we have discussed. That this is the very heart and the soul of the Indian Constitution. It is a guaranteed fundamental right itself. You can bypass the entire judicial system, approach the Supreme Court of India directly. A very important right, because all the other rights would lose their meaning if this right was not available. And Supreme Court of India has mentioned that appropriate proceedings has to be given the broadest possible and the most liberal interpretation, which basically means that you can approach the court in any format, in any procedure, in any way, as long as it is for the enforcement of a fundamental right, it will be considered as an appropriate proceeding. That is what is more important. And in case the court is satisfied that prima facie you can establish that there has been a violation of a fundamental right, then the court will go into this matter and it will definitely provide you a remedy. What remedy? That will be at the discretion of the court. Yes, clear to everyone? कोई सवाल है किसी को? नहीं सर, सेब में और फ्रूट में क्या फर्क होता है सर? क्या फर्क होता है? बस, writ is an order which is issued for the enforcement of a right. ठीक है? Now, let's discuss about the various writs that can be issued by the court in case of violation of a fundamental right. So the first writ is the writ of habeas corpus. Writ of habeas corpus. Now, all of these terms which have been mentioned in Article 32 Clause 2 as writ powers are Latin terms. Habeas corpus, a Latin term, means to have the body of. In case a person has been illegally detained or illegally arrested, and this illegal detention of a person or an individual can be both by the authority, by some authority that has power under the law, or maybe by an individual. In case a person has been illegally detained, not as per the procedure established by law, by either an authority or by an individual, then one can say that fundamental rights are getting violated. Which fundamental rights are getting violated? I can't figure out anything as long as you keep murmuring among yourself. Please raise your hands and then answer, guys. It's a very simple basic rule that हाथ आप डरते किस बात से हो? मरमर करते रहते हो? बोलो ना कॉन्फिडेंटली, गलत ही तो होगा आंसर. सर एक आदमी ने हाथ खड़ा किया वहां, है ना, आप भी हाथ खड़ा कर सकते हो और आंसर दे सकते हैं। जी सर बताइए। आर्टिकल 20 कैसे सर? प्रोटेक्शन अगेंस्ट अरेस्ट में कौन से राइट में प्रोटेक्शन अरेस्ट है क्या आर्टिकल 20? सर आपने तो रिवाइज ही नहीं किया मामला। हाँ जी, आर्टिकल 22 इज गेटिंग वायलेटेड। हाउ सर? हाउ? हाँ जी यार आप लोग सोचो। हाँ जी, सबसे पहले तो 21 वायलेट हो रहा है। योर पर्सनल लिबर्टी हैज बीन टेकन अवे विदाउट फॉलोइंग द प्रोसीजर एस्टैब्लिश्ड बाय लॉ। सबसे पहले दिमाग में वो आना चाहिए दैट आर्टिकल 21 इज गेटिंग वायलेटेड when a person has been illegally detained or arrested. Personal liberty has been taken away without following procedure established by law. Article 19 is also getting impacted. Right to movement of residence, right to movement, right to movement, right to residence, right to freedom of speech and expression is getting violated. And then of course 22 may also have been impacted. Right? Primarily तो 21 है देखिए, है ना, बिकॉज योर पर्सनल लिबर्टी, आप हमेशा बात याद रखिएगा, सबसे पावरफुल फंडामेंटल राइट 21 है, सबसे पावरफुल। उसके बाद अगर है तो फिर 14 है वो, बिकॉज सबसे ब्रॉड राइट्स हैं ये, है ना। सो आर्टिकल 21, आर्टिकल 19 एंड ऑफ कोर्स इट मे बी दैट आर्टिकल 22 इज ऑल्सो गेटिंग वायलेटेड, नॉट आर्टिकल 20 सर। थोड़ा सा रिवाइज कीजिए प्लीज चीजों को, है ना, मिक्सअप हो जाता है। आई नो 20 और 22 बहुत बार मिक्सअप हो जाता है, बट हमें याद रखना है कि 20 तो प्रोटेक्शन दे रहा है इन केसेस ऑफ कन्विक्शन, 22 दे रहा है प्रोटेक्शन इन केसेस ऑफ अरेस्ट, सेफगार्ड्स दे रहा है वो, है ना। 21 भी सेफगार्ड दे रहा है पर्सनल लिबर्टी और लाइफ को, दैट इट कैन नॉट बी टेकन अवे एक्सेप्ट अकॉर्डिंग टू प्रोसीजर एस्टैब्लिश्ड बाय लॉ। एंड 19 सेफगार्ड्स दे रहा है फ्रीडम्स के अंदर। So some people may say that even 22 is getting violated, which is also okay. But primarily it is 21 and 19, and 22 may also have been impacted. So in cases of illegal detention, one thing is sure that a person's fundamental right is definitely getting violated. Whether it has been done by an authority or whether it has been done by an individual. So if prima facie someone can approach the court and prove that a person has been illegally detained or arrested, then the court will issue the writ of habeas corpus, which basically means that present this body or present this person in front of us. Habeas corpus, corpus basically means body, right? So present this body in front of us, and if the court is satisfied that a person's fundamental right has gotten violated here, arrest and or detention was illegal, then the court will interfere and will set that person free. This is what is the writ of habeas corpus. So writ of habeas corpus is issued in cases of illegal or unlawful detention or arrest committed by an act committed by either an individual or by an authority, है ना, and in case it can be proven in the court that the person was illegally arrested, illegally detained, then the court will say that present this body in front of us, and if the court finds that yes, there was an illegal detention or an arrest, the court will set that person to be free. This is the writ of habeas corpus, a very important fundamental writ which has been provided under Article 32, Clause 2 of the Constitution. Now what you also need to understand is that let's say that our friend here got arrested illegally by some police officer. Some of you became an IPS, you realized कि यार ये बहुत सवाल पूछता था क्लास में. So जब मौका मिला तो पकड़ लिया इसको बेचारे को, राइट? ऐसा नहीं तुम्हें ही पकड़ेंगे, किसी और को पकड़ सकते हैं, ठीक है? तो इसको पकड़ लिया, ये मैडम नहीं पकड़ लिया इसको, बोला कि मैं बताऊंगी तेरे को, राइट? नाउ द क्वेश्चन इज कि ये बेचारा कैसे जाएगा कोर्ट? इसके पास ये तो illegally detained है. Who will ensure the enforcement of his fundamental right? Someone else will have to approach. But in law, there is a principle which is called as the principle of locus standi. And the meaning of the principle of locus standi is that only the aggrieved party can approach the court. तो अगर आप केवल only if you are the aggrieved party, only if you are a victim, can you approach the court. ठीक है, केवल aggrieved party ही कोर्ट अप्रोच कर सकती है. तो फिर अब ये कैसे करेगा बेचारा? He is तो already under arrest. Someone else will have to approach. So the court says that in cases of writ of habeas corpus or in cases of illegal detention, locus standi principle would not be applicable. Principle of locus standi is a principle, basic principle in law, that only an aggrieved party can approach the court for enforcement of some right which has been violated. But in cases of habeas corpus, because it will be practically difficult for a person who has been illegally detained or arrested to approach the court, any person can approach the court on behalf of that person, and therefore principle of locus standi is not applicable in cases of writ of habeas corpus. Is that clear to everyone? Yes. So habeas corpus के बारे में लिख लीजिए. Habeas corpus, it literally means, पहले लिख लीजिए one habeas corpus, it literally means to have the body of, it literally means to have the body of, full stop. This writ is issued, this writ is issued in cases of illegal arrest and detention, in cases of illegal arrest and detention by an authority or an individual. By an authority or an individual. Full stop. If a person has been detained illegally, the court will ask for the appearance of such a person, in front of it. The court will ask for the appearance of such a person in front of it. And would examine the reasons for detention. Full stop. If no legal justification is present for the same, the court will set the person free. Full stop. In case of habeas corpus, the principle of locus standi is not applicable. ठीक है. सो दिस इज द रिट ऑफ हेबियस कॉर्पस. अब दूसरी जो रिट है विच हैज बीन मेंशन्ड इज द रिट ऑफ मैंडेमस. writ of mandamus. Now mandamus means we command. It's also a Latin term. It means we command. अच्छा ये याद रखिएगा कि writ of habeas corpus can be issued against an individual or any authority or any court. Does not matter. जिसने भी illegally detain किया हो किसी भी आदमी को. Now writ of mandamus, which is called as we command. This writ is issued in those cases where due to inaction or non-performance of a statutory or a legal duty by an authority, a person's right has been violated. Then the court will issue an order, a writ to the concerned authority and ask them to do something so that the enforcement of the fundamental right of that person can happen. This is called as the writ of mandamus. Let me give you an example. So let us say these two only. Now, one of them is she gets selected in the IPS. Few years later, she goes on to become a senior officer in the CISF. This guy is still struggling. ऐसा नहीं होगा, उल्टा भी हो सकता है. So he's still struggling. 4-5 attempts he has given. Then he realizes कि यार assistant commandant का भी exam होता है CISF का. So he appears in the assistant commandant CISF exam. He becomes an assistant commandant. But she's his senior in the service. And they again have a problem going on from a long time. She has scored to settle with him. तो शी रियलाइज कि यार ये बहुत परेशान करता था कोचिंग क्लास में मुझे, अब मौका आया है, ऊंट पहाड़ के नीचे आया है. सो नाउ ही वांट्स टू अपीयर इन द एग्जाम अगेन, यूपीएससी सिविल सर्विस एग्जाम, बट द रिक्वायरमेंट इज दैट ही विल हैव टू गेट द परमिशन ऑफ द सीनियर. सुपरवाइजर का परमिशन लेना जरूरी है, एनओसी चाहिए सुपरवाइजर से. सो ही अप्रोचेज हर, सेवरल अदर्स हैव आल्सो अप्रोच्ड हर. इन्होंने सबकी एप्लीकेशन क्लियर कर दी, इस बेचारी की नहीं करी बस. शी इज सिटिंग ओवर इट फॉर मंथ्स. अब लास्ट डेट इज अप्रोचिंग for submission of the examination form to UPSC, and this guy is getting his heartbeats raised up कि यार पता नहीं क्या कर रही है, मेरे से क्या दुश्मनी है. ऐसा मैंने तो 1-2 सवाल ही ज्यादा पूछे थे क्लास में. ठीक है. So then he says कि यार she is not performing a duty which she is supposed to perform. See, the point is that she has acted in an arbitrary manner because she has given permission to everyone but not to only him, only to this guy, and she is bound to perform this duty. Either reject it or accept the application. Either she can provide the NOC or not provide the NOC, but let the poor person appear in the examination or not appear. Give the reasons that why you are not giving the NOC for appearing in the civil service examination. But that is not happening. Due to non-performance of his duty, his Article 14 is getting violated, which is basically that everyone has a right to equality. And even if equality is not there, arbitrariness should not be there. We have discussed about it already. अगर आप कोई भी arbitrary decision लेते हैं तो वो Article 14 का violation है. So now, what remedy does he have? He wants her to act, because due to non-performance of a legal duty which has been given to her, his right is getting violated. So he will approach the Supreme Court of India directly and say that so and so is the case. I am requesting you to issue a writ of mandamus to ask her or issue an order to her to either provide my permission or to go ahead with it. Basically, proceed ahead on my application that I have made for the approval that whether that I can appear in the examination or not. So the writ of mandamus will be issued, where the court will command the authority that you do something. We are asking you to do something. Because due to your inaction, due to your non-action, someone's fundamental right is getting violated. And there is a demand that has been made by this person. You have refused that demand. If the court finds that due to non-performance of a duty, which has been provided to some legal authority, a person's fundamental right is getting violated, then the court will issue the writ of mandamus to that particular authority to wake them out of their slumber, to wake them out of their sleep. This is called as the writ of mandamus. Now, writ of mandamus can be issued to not just an authority which may be an administrative authority that may not be performing its functions, but also an inferior court also, due to whose inaction a person's right has been violated. So this is the writ of mandamus which you need to understand. But keep one thing here in mind, that this writ of mandamus cannot be issued against an individual. You know, a son cannot approach the court and say that my mother is not cooking so and so thing for me. You issue the writ of mandamus. आप समझ रहे हो? एक पर्सनल प्राइवेट इंडिविजुअल के खिलाफ ये रिट इशू नहीं हो सकती. दिस is issued only in those cases where there is a legal duty which has not been performed, statutory duty which has not been performed by an authority, and then you can approach the court and ask the court to issue the writ of mandamus, asking that authority to perform that particular specific legal or statutory duty. This is called as the writ of mandamus, which basically means we command. Not issued to private individuals. Habeas corpus is issued to private individuals. Also, in cases of writ of mandamus, the principle of locus standi is applicable. So you have to be an aggrieved party. Then only the writ of mandamus will be issued. Also keep it in mind that you cannot approach the Supreme Court directly by saying that, see, she has not performed a duty, without even asking her to perform that duty. If he has not written a letter to her that please provide approval for my NOC certificate for appearing in the civil service examination, then he cannot approach the court and say that the duty has not been performed. Where have you demanded the duty to be performed? If you have demanded it and that has not been performed, then you can approach the court. But you can't just approach the court by saying that my right has been violated due to inaction of a particular authority, even when you have not demanded that action from that particular authority to be performed. So this is another important thing that we need to keep in mind, essential conditions which are required to be fulfilled in order to issue the writ of mandamus. So please write down about mandamus. Hanji. इन केस ऑफ किसी भी केस में सर, इलीगल डिटेंशन है अगर, चाहे वो प्रिवेंटिव है, प्यूनिटिव है, जो भी है, अगर लॉ के अंडर नहीं हुआ है, लीगली डिटेंशन नहीं हुआ है, सिंपल, यू कैन अप्रोच द कोर्ट. ठीक है, ब्रॉड रिट है सर, ब्रॉड पावर है. हाँ, व्हाट, सॉरी, व्हाट वीटो? हाँ, नहीं, mandamus is not something that can be issued to president or governor. It will become an anomaly that the head of the state is being issued a writ to do something by one of the organs of the state. So this writ cannot be issued to governor or the president. They are completely in their discretion. They are above these organs of the state. He is the head of the state, president or governor. वो important constitutional functionaries हैं. उनको आप डायरेक्ट नहीं कर सकती, या कि आप ऐसे कीजिए या ऐसे कीजिए. ठीक है, इट विल बी लीडिंग टू वायलेशन ऑफ प्रिंसिपल ऑफ सेपरेशन ऑफ पावर्स. इट वुड ऑल्सो बी क्रिएटिंग अ सिचुएशन वेयर एन ऑर्गन ऑफ द स्टेट वुड बी इशूइंग एन डायरेक्शन टू द हेड ऑफ द स्टेट टू डू समथिंग. ठीक है, यस. सो प्लीज राइट डाउन अबाउट रिट ऑफ मैंडेमस. मैंडेमस लिटरली मीन्स वी कमांड. It literally means we command. It demands some activity on the part of a body. It demands some activity on the part of a body to whom it is addressed. It demands some activity on the part of a body to whom it is addressed to perform some duty, which he or she has refused to perform. Which he or she has refused to perform. A court can issue a writ of mandamus. A court can issue a writ of mandamus to an authority to do something specified in the writ. To do something specified in the writ. Full stop. The objective behind this writ is to awaken the sleeping authorities. The objective behind this writ is to awaken the sleeping authorities out of their slumber. Out of their slumber. I called up one of my friends who is a DC in one of the districts on Sunday just to talk to him about something and उसने फोन नहीं उठाया. 12 बजे के आसपास मैंने किया था. उसने फिर शाम को मेरे को फोन किया तो बोल रहा था यार मैं सो रहा था दिन में. तो मैंने बोला कि यार तुम प्रशासन हो, तुम तो पूरा दिन ही सोते हो. तो बोलता हाँ हमें कोर्ट ने भी अभी एक ऑर्डर दिया दैट द अथॉरिटी हैज बीन स्लीपिंग ओवर दिस पर्टिकुलर ऑर्डर ऑफ द कोर्ट. बोला तुम्हारा तो काम ही है सोना. एनीवे, jokes apart. Now, essential conditions for issuing a writ of mandamus. Essential conditions for issuing a writ of mandamus. First, one has to prove the violation of a fundamental right. One has to prove the violation of a fundamental right. Second, such a violation must take place. Such a violation must take place due to non-performance. Such a violation must take place due to non-performance of a statutory duty. Due to non-performance of a statutory duty. And third, there has to be a demand and a refusal. There has to be a demand and a refusal to perform the duty. There has to be a demand and a refusal to perform the duty. Next line में लिखिएगा, this writ cannot be issued to a private individual, or against the president and the governor, against the president and the governor. Right? So this is the writ of mandamus. Hanji. Sir, I'll come to that. I'll come to which courts have powers to issue these writs. Yes. Any other questions? Okay. Hanji. हाँ? क्या होता है? क्या होता है? सर वीटो तो अलग ही चीज है. सर वीटो बिल्कुल अलग चीज है. वीटो कहां से आ गया इसमें? बात सेब की हो रही है, तुम बटर चिकन ले आओ बीच में. अलग चीज है सर. वीटो तो बहुत ही अलग पावर है, वीटो का क्या लेना देना रिट से? हाँ जी, आई डोंट नो सर। या देखो इतने अब स्पेसिफिक बाल की खाल तो मुझे भी नहीं पता है ना। देखो आप एक बात समझिए, मैंने हमेशा ये बात बोली है, सारे सवालों के जवाब मेरे पास नहीं है। दूसरा, आप खुद से पूछिए कि जो आप सवाल पूछ रहे हैं उसका कोई रेलेवेंस है एग्जाम के लिए? मेरे को नहीं पता, और मैं नहीं जानना चाहता हूं कि डिफेंस फोर्सेस के खिलाफ हो सकती है कि नहीं हो सकती। स्पेसिफिक केस आएगा तो जाएंगे कोर्ट और फिर पता चलेगा हो सकती है कि नहीं हो सकती, रेफरेंसेस ढूंढने पड़ेंगे, केसेस ढूंढने पड़ेंगे। तो प्रोसीजरल चीजों में अपना दिमाग मत खपाया कीजिए आप, ये आप लोगों के लिए ही है। आप मुझसे सवाल पूछोगे मेरे को नहीं पता, और मैं ये जाके चेक भी नहीं करूंगा, मैं बॉदर भी नहीं करूंगा इसके बारे में। भाई मेरे पास केस आएगा तो मैं जाऊंगा कि यार ये, अदरवाइज आई डोंट नो व्हाई शुड आई बी बॉदर। मेरे को तो बेसिक एग्जाम के पर्सपेक्टिव से कॉन्सेप्ट समझना है। देखिए आप ना, ये बड़ा इंपॉर्टेंट चीज है, क्यूरियोसिटी इज वन, बट क्यूरियोसिटी कैन लिटरली किल द कैट, एंड it will spoil your chances in the examination if you do not understand where to draw the line with curiosity, because ये subjects ऐसे हैं कि इसमें कोई limitation नहीं है सर, there is no boundary to your knowledge. You can do a complete PhD on the writ of mandamus, but do you have that time? So I don't really know sir. ठीक है, हाँ जी। पता नहीं सर, ये देखो आप ना स्पेसिफिक केसेस पूछ रहे हो, वो भी हाइपोथेटिकल। सर काम ऐसे नहीं होता लॉ में, मैं कैसे समझाऊं आप लोगों को? सर प्राइवेट इंडिविजुअल्स के खिलाफ ये रिट इशू नहीं होती है, तो मेरा अजम्पशन ये है कि प्राइवेट इंस्टीट्यूशंस के खिलाफ भी नहीं होती है। अब ये डिटेल कि क्या प्राइवेट इंस्टीट्यूशन के खिलाफ, देखिए आप ब्रॉड बात समझिए, उस इंस्टीट्यूशन में, उस अथॉरिटी में एक लीगल ड्यूटी वेस्टेड होनी चाहिए ऐसा कुछ करने की, लीगल ड्यूटी। तभी मैंने बोला देयर शुड बी अ स्टैट्यूटरी ड्यूटी। अब आप वो एग्जामिन कीजिए कि वो स्टैट्यूटरी ड्यूटी है कि नहीं है। अब आप जो केस दे रहे हैं सर वो तो हाइपोथेटिकल है, मैं कमेंट नहीं करूंगा उसके ऊपर अनटिल अनलेस कोई स्पेसिफिक आप मैटर निकाल के लाइए मेरे सामने। और उसमें भी देखिए मैं नहीं डिसाइड कर सकता हूं, ये मैं सुप्रीम कोर्ट नहीं हूं। अब बात समझिए, बात देखिए, मैं एक बात मैं समझा के थक गया हूं आप लोगों को कि आप ये समझिए कि स्पेसिफिक इंस्टांसेस अगर मैं निकाल के क्वेश्चन बनाऊं अपने दिमाग में कि ऐसा होगा तो कैसा होगा, मुझे नहीं पता। एक दिन किसी एक स्टूडेंट ने मुझसे आगे पूछा कि सर आपने बोला कि कॉन्स्टिट्यूएंट असेंबली जो है वो डायरेक्टली इलेक्टेड नहीं थी, अगर कॉन्स्टिट्यूएंट असेंबली डायरेक्टली इलेक्टेड होती तो क्या होता? तो मैंने उसे बोला कि यार मेरी मम्मी के मूछे होती तो क्या मैं उनको पापा बुलाता? आप समझो मेरी बात को यार। you know, if ifs and buts is what we have to supposed to get in, then it will become very difficult, guys. See, I understand, I am not disrespecting your question, but try to understand that I don't know. This is what is the basic part of it. Now, whether it can be issued against an educational institution, you will have to examine the facts of the case. ये तो एक कोर्ट का केस बन जाता है पूरा, that can the writ of mandamus be issued against them or not. Then the court itself will first have to see that whether there is a legal duty that is vested in that authority or not. Are they duty bound to perform that particular duty or not? Has there been a refusal to perform that duty or not, and then the court will examine this. ऐसे चलता है मामला कोर्ट में. तो स्पेसिफिक हाइपोथेटिकल केसेस का कोई आंसर नहीं है मेरे पास, क्योंकि सवाल हाइपोथेटिकल है तो जवाब भी हाइपोथेटिकल ही होगा. आप समझिए बात को, है ना. सो नो डिसरिस्पेक्ट टू एनी ऑफ योर क्वेश्चंस, बट प्लीज अंडरस्टैंड दैट ऑल दीज मैटर्स डिपेंड फ्रॉम अ केस टू केस. हमें यहां पे बेसिक ये समझना है कि इसका मतलब क्या है. अब क्या ये इसको इशू हो सकती है, उसको इशू हो सकती है, ये तो फैक्ट्स ऑफ द केस पे डिपेंडेंट होगा सर, ये नहीं बता सकते. देखिए ये इट्स एज सिंपल एज लाइक कि भाई मैंने एक आदमी को कल मर्डर करते हुए देखा, तो क्या सर उसको फांसी हो जाएगी? मैं कैसे बताऊं भाई, हो सकती है, नहीं भी हो सकती. फैक्ट्स ऑफ द केस पे डिपेंड करेगा, राइट. I'm trying to draw an analogy here and trying to tell you that ये specific questions का कोई जवाब नहीं है specific, क्योंकि ये specifically hypothetical questions है ना. Yes, any other questions? Okay. Now the third and the fourth writ which we need to understand, both of them need to be read together. The writ of certiorari and writ of prohibition. Okay. So both of them are actually very similar to each other, but there is still a difference between them. And see, in no way please consider this that I am trying to kill your curiosity. You are more than welcome to go and do your research. But एग्जाम के लिए ये सब क्वेश्चंस का कोई सेंस नहीं है. आप लॉ के स्टूडेंट होते तो मैं बिल्कुल बोलता कि हां जी पता नहीं, मेरे को भी पढ़ना पड़ेगा, बट इतना तो डिटेल में मैंने भी रिसर्च नहीं किया सर. ठीक है. नाउ सर्चोरारी एंड प्रोहिबिशन. Now, certiorari and prohibition are both issued in the same kind of cause. The only difference between certiorari and prohibition is that one is issued at a much earlier stage and one at a later stage. Writ of prohibition and certiorari, what are these writs? So, in case the court finds out that a lower court, an inferior court, or a tribunal has exceeded its jurisdiction. Exceeded matlab either it has exceeded its jurisdiction in terms of territorial jurisdiction. Let's say a lower court in Bihar has entertained a case that originated in Maharashtra. The cause of action, let's say a murder happened in Maharashtra. The cause of action lies in Maharashtra. Everything happened in Maharashtra, but someone has gone and registered a FIR and somehow it has been registered in Bihar, and then after that the case trial is happening in Bihar. This is exceeding the jurisdiction of the court, because ये जब cause of action उनकी territory में नहीं है तो बिहार की court के पास ये jurisdiction भी नहीं है that it can try that case. One is that. The second thing is that let's say if a court has exceeded its jurisdiction in terms of subject matter as well. Let's say there is a tax tribunal which is supposed to hear cases related to tax, and someone files a complaint or a case, a suit in the tax tribunal which relates to murder, and the tribunal starts hearing that particular dispute or case. They will be exceeding their jurisdiction because that is not their area, that is not their jurisdiction, not subject matter for them to look into. So if there has been a excess of jurisdiction that has been exercised by an inferior court or a tribunal, or if the lower court or the tribunal has prima facie shown violation of principles of natural justice, they have not heard both the parties properly, or there has been a prejudice or bias on the part of the court, then in that case, the court can issue the writ of certiorari or prohibition depending upon the stage at which the case is. If the order has already been pronounced in a lower court, where they have either exceeded their jurisdiction or violated the principles of natural justice, or there has been a gross miscarriage of justice प्राइमा फेसाई, देख के ही पता चल रहा है कि भाई कोर्ट ने तो ये गलत काम किया है, देन इन दैट केस द कोर्ट कैन इशू द रिट ऑफ सर्शोरारी, अगर फाइनल ऑर्डर इशू हो चुका है, बिकॉज रिट ऑफ सर्शोरारी इज इशूड टू क्वॉश द प्रोसीडिंग्स ऑफ अ लोअर कोर्ट. क्वॉश बेसिकली मीन्स टू दबा देना, कुचल देना. To quash the proceedings or to quash the order of a lower court, the court can issue the writ of certiorari to a lower court or a tribunal. Whereas writ of prohibition is issued in those cases where the court is yet to provide an order, but it is to stop the court. Prohibition का मतलब क्या होता है? To stop. So the court can issue an order to stop the lower court or the tribunal from proceeding any further. तो एक तरीके से कह सकते हैं that writ of prohibition is a preventive writ, so that the lower court does not do something that may lead to violation of a fundamental right, whereas writ of certiorari is a curative writ, which is to cure something wrong which has been done by a lower court or a tribunal. Certiorari is called to certify. इसका मतलब है to certify that are we certifying the actions of a lower court or a tribunal or not. तो स्टेज का डिफरेंस है बस, कौन सी स्टेज पे आप कोर्ट के पास जाते हैं. Prohibition at a much earlier stage, certiorari at a much later stage when an order has already been issued by a lower court or a tribunal. अब एक और सवाल आता है कि मैं बार बार बोल रहा हूं लोअर कोर्ट और ट्राइब्यूनल, लोअर कोर्ट और ट्राइब्यूनल. सो व्हाट इज द डिफरेंस बिटवीन अ कोर्ट एंड अ ट्राइब्यूनल एंड आर दे द सेम थिंग? द आंसर इज ऑफ कोर्स नॉट. Tribunal is a very different thing, court is a very different thing. Court is that authority in whom power has been vested of hearing disputes and matters by the law, by the constitution. उनका काम ही वो है disputes hear करना. और कोर्ट जो है वो एक स्पेसिफिक इंस्टीट्यूशन है, कोर्ट है. ट्राइब्यूनल क्या है? ट्राइब्यूनल इज नथिंग बट अ बॉडी दैट एक्ट्स लाइक अ कोर्ट, acts like a court, not as a court, acts like a court in situations, in certain specific situations where there are dispute between two parties. So tribunal is any body which is like a court, which hears dispute between two parties and pronounces judgment. For example, in India, DC or the institution of SDM has been provided jurisdiction over revenue matters. Land revenue matters के ऊपर अगर कोई मैटर कोर्ट के सामने जाता है, if it goes in front of the SDM, then the SDM will hear the dispute. SDM की कोर्ट बैठती है, तभी वो सब डिविजनल मजिस्ट्रेट है या डिस्ट्रिक्ट मजिस्ट्रेट है, क्योंकि उनके अंदर कुछ मजिस्ट्रियल पावर्स भी हैं, बट केवल रेवेन्यू मैटर्स में है, क्रिमिनल मैटर्स वगैरह में नहीं है. ओनली इन रेवेन्यू मैटर्स. इफ देयर इज अ रेवेन्यू मैटर विच इज देयर, देन वन गोज टू द कोर्ट, one goes to the SDM or to the DC. The DC will pronounce a judgment after hearing the disputes of both the parties, which will be similar to order of a court but not an order of a court. They are exercising certain quasi judicial powers or powers like a tribunal. इंडिया में बहुत सारे ट्राइब्यूनल्स क्रिएट किए गए. वी विल डिस्कस अबाउट देम एंड वी विल डिस्कस 323A, 323B. जैसे टैक्सेशन मैटर्स हैं, कंपनी लॉ मैटर्स हैं. There is a dispute between two companies or two partners of a particular company, two directors of a company. Now one is that you go to the courts. Ab courts are already overloaded with work. Plus on top of that, the decision making in the courts is very slow because the process is very slow. They follow all the rules of evidence and CRPC, CPC, etc. and all of that. And then already court are overburdened, loaded, and this is not their specific area of expertise. कंपनी लॉ मैटर्स, कंपनी लॉ उनका स्पेसिफिक एरिया ऑफ एक्सपर्टीज नहीं है, उनका एरिया है सिविल मैटर्स, उनका एरिया है क्रिमिनल मैटर्स. सो इन इंडिया वी हैव क्रिएटेड ट्राइब्यूनल्स फॉर दीज स्पेसिफिक पर्पसेस so that quick disposal of cases can take place related to specific matters. service related matter है, आपकी प्रमोशन रोक दी गई है for some arbitrary reason. अब एक तरीका तो ये है कि you go to the court और फिर लड़ते रहिए आप 15-20 साल कोर्ट के अंदर. by that time your career will be already done. or the other is that you go to the CAT. if you are a central services officer, you have gone to Central Administrative Tribunal, विच इज नॉट अ कोर्ट. वहां पे कुछ लोग होंगे जो कि अपॉइंटेड बाय द एग्जीक्यूटिव बैठे होंगे, बट दे विल बी एक्सरसाइजिंग क्वाजी जुडिशियल पावर्स सो दैट केसेस कैन बी डिस्पोज्ड ऑफ क्विकली, एंड प्लस दे हैव एक्सपर्टीज इन एडमिनिस्ट्रेटिव मैटर्स, सो दे नो द काइंड ऑफ केसेस दैट कम अप. सो ट्राइब्यूनल्स डू नॉट अप्लाई दीज रिजिड रूल्स विच आर अप्लाइड इन द कोर्ट्स ऑफ एविडेंस एक्सेट्रा. तो ये जल्दी प्रोसेस मूव होता है ट्राइब्यूनल्स में. we'll discuss more about tribunals, but idea is that this writ, both certiorari and prohibition, can be issued against a lower court or a tribunal by the superior courts, high courts and the Supreme Court in India. What you need to keep in mind though is that in some of the texts it is mentioned that tribunals, writ of certiorari and prohibition can be issued only against courts, cannot be issued against administrative authorities. It is not completely correct, because there are chances where an administrative authority may be acting like a quasi judicial body, for example DC or a SDM. In that case, when they are acting like a quasi judicial body, a writ of certiorari or prohibition can be issued against them. Not in normal circumstances. Let's say when I am exercising my powers as a DC to take decisions with respect to health matters in my district, then the court cannot issue a writ of certiorari, because वो executive matter है, separation of powers का violation होगा. पर अगर मैं as a administrative authority एक क्वाजी जुडिशियल बॉडी की तरह काम कर रहा हूं, एक ट्राइब्यूनल की तरह काम कर रहा हूं, जहां पे मैं दो पार्टीज के बीच का डिस्प्यूट हियर करके एक डिसीजन दे रहा हूं, then in that case the court can issue a writ of certiorari or prohibition. The only difference being the stage at which they are issued. If writ of certiorari is issued, then the proceedings of the lower court or the tribunal will be quashed completely, and then the matter will be taken up by that higher court which has issued that writ of certiorari. And if the writ of prohibition is issued, the lower court or the inferior tribunal will be stopped from proceeding any further on that particular case, and the case will be put in front of the higher court which has issued that writ. Is that clear to everyone? So prohibition and certiorari as writs. Now whether they can be issued against X and Y or Z specifically, very difficult to answer. Specific cases देखने पड़ेंगे, specific facts देखने पड़ेंगे. But broadly what we need to remember is that they can be issued against even an administrative authority, apart from, of course, inferior courts, in case an administrative authority is acting like a quasi-judicial body or a tribunal. Is that clear to everyone? Right? तो पहले लिख लीजिए, then if there are any questions, we'll take it up. Writ of certiorari. Certiorari means to certify. Certiorari means to certify. The writ is issued by the court. This writ is issued by the court to quash the order. To quash the order of an inferior court or a tribunal. To quash the order of an inferior court or a tribunal, to ensure the enforcement of a fundamental right. To ensure the enforcement of a fundamental right. This writ is issued when an inferior court this writ is issued when an inferior court has either exceeded its jurisdiction or usurped a jurisdiction usurp मतलब हड़प लेना, ठीक है, usurped a jurisdiction with which it is not legally vested, or if the court has acted contrary to the principles of natural justice, or because the decision has been obtained by fraud or corruption. Full stop. This writ can only be issued to an inferior court or a tribunal. And the Supreme Court has held in multiple cases that whenever a body of persons has legal authority to determine questions affecting the rights of the subjects, a writ of certiorari may be issued. Therefore, one can say that a writ of certiorari can be availed. Only to remove the validity of judicial acts, including the exercise of quasi-judicial powers by administrative bodies in contrast with what are purely administrative actions. तो मैं बस ये कह रहा हूं कि क्वाजी जुडिशियल बॉडी या लोअर कोर्ट को ही ये रिट इशू की जा सकती है. This writ cannot be issued to an administrative body acting in its administrative authority or taking administrative decisions. Only when an administrative body is acting like a tribunal or a quasi-judicial body can the writ of certiorari be issued. Last line लिख लीजिए that the principle of locus standi is applicable. The principle of locus standi is applicable. और नेक्स्ट लिखिएगा रिट ऑफ प्रोहिबिशन. रिट ऑफ प्रोहिबिशन it is issued by the court. It is issued by the court to an inferior court. It is issued by the court to an inferior court or a tribunal forbidding the latter मतलब inferior court or tribunal, okay, forbidding the latter to continue the proceedings. Certiorari is issued to quash the final order. Certiorari is issued to quash the final order, whereas the writ of prohibition is issued to prohibit the court or a tribunal from making an ultra vires order. Ultra vires basically means illegal order. From making an ultra vires order. Full stop. Therefore, one can say that the writ of prohibition is available during the pendency of proceedings, and before the final order is made. Whereas certiorari can be issued only after the final order has been made. Can be issued only after the final order has been made. एक बार give a couple of minutes, read whatever you have written. और कुछ समझ में नहीं आया है, किसी को कोई डाउट है, something is not understood, something is not clear, please ask. किसमें? सर कोई आदमी आपको पकड़ के रख ले तो फिर क्या होगा? मैं आपको पकड़ के अभी यहां पे कमरे में बंद कर दूं ऐसे सवाल पूछने के लिए. आई डिटेन यू. आपका फंडामेंटल राइट वायलेट हो रहा है. एक इंडिविजुअल कर रहा है, तो क्या मेरे खिलाफ ये रिट इशू हो सकती है? हाँ. That is what it means when we say that this writ can be issued against an individual or an authority. Even a private individual who has detained a person illegally can be issued this writ and be asked to release that person. That is what is called as that this writ can be issued against an individual or an authority both. But mandamus की writ आप किसी private individual के खिलाफ नहीं कर सकते. समझ रहे हैं? कि आप मेरे खिलाफ एक रिट इशू करवाओ कि यार ये आदमी जो है मेरे को ये कॉन्सेप्ट नहीं पढ़ा रहा, मेरे पे लीगल ड्यूटी नहीं है आपको पढ़ाने की कोई, समझ रहे हैं? इफ देयर इज अ लीगल ड्यूटी विच हैज बीन वेस्टेड इन एन अथॉरिटी to perform something as a result of which, non-action of which your fundamental right is getting violated, then you can approach the court. So केवल हेबियस कॉर्पस एक ऐसी रिट है जो कि आप एक इंडिविजुअल के खिलाफ भी इशू कर सकते हैं. प्रोहिबिशन, सर्शोरारी, मैंडेमस कैन नॉट बी इशूड अगेंस्ट एन अथॉरिटी, अगेंस्ट एन इंडिविजुअल. दैट इज व्हाट इज द मीनिंग ऑफ दैट. ठीक है? यस सर. समझा नहीं मैं क्या कह रहे हैं. ऐसे ही चले जाओगे अपनी मर्जी से? सर ऐसे नहीं होता. देखिए, अपील और सर्शोरारी में बहुत फर्क है. हर केस में आपके पास कोई राइट नहीं है कि आप हाई कोर्ट जाएंगे और हाई कोर्ट आपकी अपील एक्सेप्ट कर लेगी. ऐसा नहीं होता. हाई कोर्ट will accept the appeal against lower orders court only when the high court realizes that there is a substantial question of law that is involved, or only in specific cases. सपोज कीजिए कि लोअर कोर्ट ने आपको डेथ पेनल्टी दे दी है, तो आप एज अ मैटर ऑफ राइट जा सकते हो हाई कोर्ट अपील करते हुए. अदरवाइज जरूरी नहीं है कि हायर कोर्ट आपकी अपील एक्सेप्ट करेगी. ऐसा नहीं होता है सर. मूवीज नहीं है ये कि जी हम किसी भी लोअर कोर्ट के डिसीजन के खिलाफ हाई कोर्ट जाएंगे, हम हाई कोर्ट जाएंगे. अब ऐसे नहीं होता. हाई कोर्ट मे और मे नॉट एक्सेप्ट योर अपील. फिर क्या करोगे? दे विल रिजेक्ट योर अपील. दे विल से कि हमें नहीं एग्जामिन करना वापस से मैटर, टाइम वेस्ट कर रहा है आदमी कोर्ट का. क्लियर है? दिस इज एज ब्रॉड एज डे एंड लाइट. राइट? सो दे विल से कि वी आर नॉट गोइंग टू एंटरटेन दिस केस एनी फर्दर. सो अपील मैकेनिज्म में कोई आपका राइट नहीं है सर. सर्शोरारी में अगर आपने प्रूव कर दिया प्राइमा फेसाई कि लोअर कोर्ट गलत तरीके से ऑपरेट करी है. देखिए बात समझिए. इन केस ऑफ अपील ना, you go against the decision of a lower court, contesting the facts or contesting the interpretation that has been made by the lower court. In case of certiorari, you are going against the patently illegal way in or the manner in which the lower court has exercised its powers. फर्क है. अपील में आप किसी एक फैक्ट को लेकर या किसी डिसीजन के खिलाफ जा रहे हैं. यहां पे आप डिसीजन के खिलाफ नहीं जा रहे हैं. केवल आप जिस तरीके से कोर्ट एक्ट करी है उसके खिलाफ ऊपर जा रहे हैं और बोल रहे हैं कि देखिए, बिकॉज दे हैव एक्टेड इन सच एन आर्बिट्ररी मैनर और दे हैव एक्सीडेड देयर जुरिस्डिक्शन, दे आर वायलेटिंग देयर फंडामेंटल राइट एज अ रिजल्ट ऑफ इट. तो वहां पे आपके पास राइट है सर्शोरारी में. इन केस ऑफ अपील इट मे और मे नॉट बी कंसिडर्ड बाय द हाई कोर्ट और द सुप्रीम कोर्ट. जरूरी नहीं है. इनफैक्ट फॉर दैट मैटर आप सपोज कीजिए, मैं तो लोअर कोर्ट से हाई कोर्ट की बात कर रहा हूं, हाई कोर्ट से सुप्रीम कोर्ट में देयर आर वेरी फ्यू अपील्स दैट सक्सीड बिकॉज यू विल हैव टू गेट अ सर्टिफिकेट फ्रॉम द हाई कोर्ट दैट दिस मैटर इज फिट फॉर कंसिडरेशन ऑफ द सुप्रीम कोर्ट. अदरवाइज सुप्रीम कोर्ट आपका मामला नहीं सुनेगी. ऐसे बात समझ रहे हैं? हाई कोर्ट ने आपके खिलाफ डिसीजन दिया, ये नहीं है कि जी हम सुप्रीम कोर्ट जाएंगे. ऐसे कैसे चले जाओगे? आपको हाई कोर्ट के, हम डिस्कस करेंगे जब हम जुडिशरी का चैप्टर डिस्कस करेंगे, हाई कोर्ट को सर्टिफिकेट देना पड़ता है कि हां जी ये इंपॉर्टेंट मैटर है और हम बोल रहे हैं कि यस वी हैव गिवन अ डिसीजन ऑन दिस बट लेट द सुप्रीम कोर्ट ऑल्सो हैव अ से ऑन दिस मैटर. सो सुप्रीम कोर्ट जाना कोई आपका प्रेरोगेटिव या राइट नहीं है अपील मैकेनिज्म में. ये बात समझिए, है ना? दिस इज व्हाट इज द डिफरेंस बिटवीन एन अपील मैकेनिज्म एंड सर्शोरारी. या तो आप स्पेशल लीव पिटीशन लगा के जाइए सुप्रीम कोर्ट, वो भी हम डिस्कस करेंगे, वो भी जरूरी नहीं है एक्सेप्ट हो. स्पेशल लीव पिटीशन क्या होता है कि आप सीधा हाई कोर्ट या लोअर कोर्ट से मामला निकाल के सुप्रीम कोर्ट के सामने ले जाइए. बट ऐसे ही नहीं होता वो. इट हैपेंस ओनली इन 1 to 2% केसेस और उसके लिए आपको लोअर कोर्ट की परमिशन नहीं चाहिए, सुप्रीम कोर्ट या लोअर कोर्ट की परमिशन नहीं चाहिए, या हाई कोर्ट की परमिशन नहीं चाहिए सुप्रीम कोर्ट जाने के लिए. सो इट्स नॉट हाउ यू थिंक इट इज. ओके, सो दैट इज द डिफरेंस बिटवीन सर्शोरारी एंड अपील मैकेनिज्म. क्लियर हो गया सर? ठीक है. यस, एनी अदर क्वेश्चंस? हाँ जी. सॉरी, you do this matter in what sense? हाँ. नहीं सर, ऐसे देखिए, आप ना हवा में बात कर रहे हो सर. ऐसे नहीं चलती चीजें. वी विल डिस्कस अबाउट द अपील मैकेनिज्म एंड हाउ द मैटर्स आर टेकन अप इन द अपील मैकेनिज्म. बट ऐसा नहीं होता कि हाई सुप्रीम कोर्ट के सामने मामला गया, आप सुप्रीम कोर्ट बोले कि जाओ हाई कोर्ट के पास चले जाओ. सी, व्हाट यू नीड टू अंडरस्टैंड इज कि कोर्ट विल फर्स्ट कंसिडर. पहली बात तो आप सुप्रीम कोर्ट में सीधा मैटर ले जा ही नहीं सकते एक्सेप्ट फंडामेंटल राइट्स का मैटर हो तो, या फेडरल डिस्प्यूट हो. और आइडियली तो सुप्रीम कोर्ट शुड नॉट बी टेलिंग a citizen who has approached the Supreme Court directly in case of violation of a fundamental right that you please go to the High Court first. But पिछले कुछ दिनों में ऐसा हुआ है. When citizens have approached the Supreme Court has said that yes, there has been a prima facie violation of the fundamental right, and then they have directed that citizen to go to the High Court. ये patently unconstitutional है देखा जाए तो, पर सुप्रीम कोर्ट है, जो करना चाहे कर सकती है. Ideally, this is not something which should happen. Okay. We'll discuss about appeal mechanism, etc., and all of those things when we will discuss the judiciary and the powers of the High Court and the Supreme Court and the jurisdiction of the High Court and Supreme Court. Yes. Any questions still here? ये पढ़ लिया आपने, इसमें कोई दिक्कत है किसी को? In case of prohibition writ, how a higher court can decide before proceeding that an inferior court will not give a satisfactory final order. See, it's not about whether they will give a satisfactory or not. ये satisfactory की बात नहीं हो रही है यहां पर. अगर सुप्रीम कोर्ट को दिखता है या हाई कोर्ट को दिखता है कि देयर इज एन एक्सरसाइज इन द एक्सेस ऑफ जुरिस्डिक्शन दैट इज टेकिंग प्लेस, और द लोअर कोर्ट इज एक्टिंग इन एन बायस्ड मैनर, डिसीजन की तो बात ही नहीं हो रही. देखिए, आप लोग बात नहीं समझ रहे हैं. ये अपील का मैकेनिज्म नहीं है सर्शोरारी और प्रोहिबिशन. आप कोर्ट के एक्शन के खिलाफ ही कोर्ट जा रहे हो. डिसीजन से कोई लेना देना नहीं है, वेदर इट इज इन योर फेवर और अगेंस्ट यू. इट्स नॉट अपील. सर्शोरारी एंड प्रोहिबिशन इज नॉट अपीलिंग अगेंस्ट द डिसीजन ऑफ अ लोअर कोर्ट. It is basically calling out the action of a lower court as patently illegal and unconstitutional, कि गलत काम किया है इन्होंने. देखिए, एक होता है कि सर इन्होंने डिसीजन जो दिया है वो गलत दिया है. एक है कि जिस तरीके से इन्होंने डिसीजन दिया है, जैसे इन्होंने अपने आप को कंडक्ट किया है, यही गलत है. ये मैटर इनका था ही नहीं, ये इसको डिसीजन दे रहे हैं. ये है सर्शोरारी और प्रोहिबिशन का रोल. Appeal is a different matter altogether. Don't confuse it with appeal. Any other questions? Okay. So this is about writ of certiorari and prohibition. We'll go into a break now, and after the break, I will take up the writ of quo warranto. And then we will proceed to talk about further that whether other courts in the country also have these jurisdiction or not, writ jurisdiction or not, and whether that can be extended to on them or not, and how that can be extended, and all of those things. Okay. So I'll see you in a few minutes. So the writ of quo warranto is issued in those cases where a public office has been illegally occupied by some person who does not have authority to do so. So quo warranto as a term literally means where is your warrant. So quo warranto basically means where is your warrant, or essentially warrant of appointment? There may be an instance where a person who may not be appointed to a particular office or supposed to occupy a particular office may go on and occupy some public office without any authority. In such cases, a person can approach the court and ask for the writ of quo warranto to be issued, where the court will ask that person that show me your warrant of appointment to this particular office. And if there is no warrant of appointment, there is no right that has been given to that person to occupy that public office, then the court can issue a writ for removal of that person or ousting that person from that particular government or public office. This is called as writ of quo warranto. This is basically to ensure that a person who is not supposed to occupy a position which is a public position or a public office occupies it and exercises powers contrary to the provisions of the Constitution. This is called as writ of quo warranto, as simple as that. Okay, so please write down quo warranto. Quo warranto, or it means where is your warrant of appointment? It means where is your warrant of appointment? It is a writ issued by the court. It is a writ issued by the court to examine the legality, of the claim of a person, to examine the legality of the claim of a person to a legal office, to a public office, to a public office. Full stop. If the person is not able to show a legal right, if the person is not able to show a legal right to occupy that office, then the court can order that person to be removed from the office. The court can order that person to be removed from the office. Full stop. For a writ of quo warranto to be issued, any such office in question must be public in nature, and must be created under the law, Full stop. In a nutshell, one can say that a writ of quo warranto lies against the person who is not entitled to hold the office and is only a usurper and is only a usurper of such an office, and is only a usurper of such an office. और इसमें प्रिंसिपल ऑफ लोकस स्टैंडाई एप्लीकेबल नहीं होता है. So please write down the principle of locus standi is not applicable. Out of the 5 writs, only in 2 cases principle of locus standi is not applicable, in habeas corpus and in quo warranto. In mandamus, certiorari and prohibition, the principle of locus standi is applicable. Quo warranto as a writ. So these are the 5 writs that have been mentioned in Article 32 and 226 of the Indian Constitution, which are given to the Supreme Court and the High Court. Now see, one question that arises is that, is this power to issue writs available to the other courts in the country as well, apart from the High Court and the Supreme Court? The answer is no. In order to ensure uniformity in the enforcement of these writs, these powers have only been given to the Supreme Court and the High Court, because rights का matter है, या तो fundamental right या statutory right, तो आप ये लोअर कोर्ट या इंफीरियर कोर्ट के हाथ में नहीं दे सकते, कॉन्स्टिट्यूशनल कोर्ट के हाथ में होना चाहिए. दैट्स व्हाई दिस पावर हैज बीन गिवन ओनली टू द सुप्रीम कोर्ट एंड द हाई कोर्ट्स इन इंडिया. दो आर्टिकल 32 क्लॉज 3 ऑफ द इंडियन कॉन्स्टिट्यूशन स्टेट्स दैट पार्लियामेंट बाय लॉ, Parliament can make a law and extend these writ powers that have been mentioned in Article 32 to the other courts as well in the country. किसी स्पेसिफिक कोर्ट को अगर ये रिट पावर एक्सटेंड करनी हो तो वो भी कर सकती है, बट पार्लियामेंट के पास ही केवल ये पावर है, एंड पार्लियामेंट कैन मेक अ लॉ इन ऑर्डर टू एक्सटेंड दैट पर्टिकुलर रिट पावर टू सम अदर कोर्ट इन द कंट्री. बट while extending such writ power to the other courts, there should be no prejudice to the writ powers of the Supreme Court of India. So if you read Article 32 clause 3, that makes the story clear. It reads that without prejudice to the powers conferred on the Supreme Court by clause 1 and 2, Parliament may by law empower any other court to exercise within the local limit of its jurisdiction all or any of the powers exercisable by the Supreme Court under clause 2. तो कोई भी रिट पावर एक्सटेंड करने की पावर है पार्लियामेंट के पास टू अदर कोर्ट्स इन द कंट्री बाय मेकिंग अ लॉ फॉर दैट पर्टिकुलर स्पेसिफिक पर्पस. Again, the idea is that only Parliament should do so, so that there is uniformity, so that not just any random court is given this particular writ power or is extended upon them, which has been given to the Supreme Court, and also it should not come with prejudice to the Supreme Court of India. Is that clear? Now, the other thing which we also need to keep in mind is that Article 32 cannot be suspended at any time except if it has been provided for in the Constitution. Article 32 clause 4 says that the right guaranteed by this article shall not be suspended except as otherwise provided for by this Constitution. Is that clear? Now let's write down the difference between the writ powers of the Supreme Court and the High Court. तो 2-3 पॉइंट है, जल्दी से लिख लीजिएगा. डिफरेंस बिटवीन writ power of Supreme Court and High Courts. तो पहला तो यह है दैट सुप्रीम कोर्ट कैन इशू रिट्स ओनली फॉर एनफोर्समेंट ऑफ फंडामेंटल राइट्स, राइट? तो वो लिख लीजिए. Supreme Court can issue writ only for the enforcement of fundamental rights. whereas high courts can issue writs for fundamental rights as well as statutory rights. So in this sense, one can say that the writ power of the high courts are broader or wider than that of the Supreme Court in the country. Second is, in terms of territorial jurisdiction, Supreme Court has territorial jurisdiction over the entire country. So it can entertain writ petitions from the entire country, whereas high courts can only entertain writ petitions from area within their jurisdiction. So one can say that the writ powers of the High Court are narrower in terms of territorial jurisdiction when it comes to the as comparison to the Supreme Court. And secondly, Supreme Court cannot refuse, as it is duty bound to issue a writ in case of violation of a fundamental right. Whereas High Court can issue a writ, can refuse, as it is not duty bound. And then of course, the power to approach the Supreme Court for the issuing of the writ is itself a fundamental right, whereas it is not a fundamental right to approach the High Court in case of asking them for issuing of the writ. So that is the difference between the writ powers of the Supreme Court and the High Courts in the country. अब इसमें क्वेश्चंस जो हैं, देखिए प्रीलिम्स में काफी सारे क्वेश्चंस आते हैं इस टॉपिक से. They may ask you that against whom it can be issued, against whom it cannot be issued. For example, habeas corpus can be issued against an individual as well as a authority. Prohibition and certiorari can only be issued against an inferior court or a tribunal or an administrative body acting like a tribunal. Right? तो इस तरीके के क्वेश्चंस पूछे जाते हैं. Second question, kind of question that are asked is कि भाई they will try to compare the writ powers of the Supreme Court and the High Courts. Third kind of question can be that whether only Supreme Court and High Courts have been provided with these powers. Yes, only Supreme Court and High Court has been provided with these powers, but Parliament may extend these writ powers to the other courts in the country, which has not happened till now. Right? So those are some of the kind of questions that can be asked in prelims examination, apart from asking that basic meaning kya hota hai in writ powers ka or all of those things. Then other than that, in mains examination, UPSC may give you a question that what are the various writ powers that have been provided to the Supreme Court of India? Explain each one of them, discuss each one of them, and it may ask you to compare the writ powers of the Supreme Court with that of the High Courts in the country, so you will have to provide the comparison. Is that clear to everyone? Yes, any questions? So Article 32 का basic ये है. अब इसमें एक चीज और समझनी है. I told you that principle of locus standi is applicable in some cases and principle of locus standi is not applicable in certain cases. But then during the late 70s, a question started to come up in front of the court that what about those people, those who are illiterate, what about those people, those who do not have powers to approach the court, जिनके पास approachability नहीं है court की, उन citizens का क्या? If there is a tribal living in some jungle, remote jungle of Chhattisgarh, his right has gotten violated, then how will that person approach the Supreme Court? There is a group of tribals whose rights is being violated by the state. They do not have the means, they do not have the understanding to approach the Supreme Court for the enforcement of their fundamental rights because they are weak, they are marginalized. तो क्या उनके fundamental rights को violate होते दे रहे? Of course not. So then the question emerged that what can be done? The court started a new regime in India, which is called as the regime of the PIL or public interest litigation. Now, public interest litigation basically is an innovation made by the Indian judiciary, where it says that we can relax the principle of locus standi in those cases where a person who is a public spirited individual approaches the court on behalf of the weak and the disadvantaged sections of the society. So, if a public spirited individual approaches the court on the behalf of the weak and the marginalized, for the enforcement of fundamental rights or for the enforcement of any rights, the court can relax the principle of locus standi. That is what is the entire concept of PIL, कि कोई भी public spirited individual court approach कर सकता है on behalf of the weak and the marginalized sections of the society who may not have approachability to the court. और locus standi के principle को court relax कर सकती है उन instances में in order to ensure that justice is done to the weak and the marginalized and the disadvantaged sections of the society. That is what is the concept of public interest litigation. Public interest में आप कोर्ट के पास जा सकते हैं जहां पे वो लोग जिनका फंडामेंटल राइट वायलेट हुआ है खुद कोर्ट नहीं अप्रोच कर पा रहे हैं. बट सी, अगर आपका खुद का पर्सनल इंटरेस्ट इन्वॉल्व है और आप पब्लिक इंटरेस्ट बना के कोर्ट जा रहे हैं तो देन इट विल नॉट बी एक्सेप्टेड एज अ पब्लिक इंटरेस्ट लिटिगेशन. यू विल हैव टू शो दैट देयर इज द लार्जर इंटरेस्ट ऑफ द पब्लिक दैट इज इन्वॉल्व्ड which is getting violated as a result of certain action or inaction and therefore the court should interfere. आपका प्राइवेट इंटरेस्ट नहीं होना चाहिए, वो आप उसको PIL बना के नहीं जा सकते कोर्ट फिर. In the interest of the public. Also see, court can suo motu also take cognizance. Supreme Court of India has extraordinary powers to do complete justice under Article 142 of the Indian Constitution. So therefore, if the Supreme Court finds, if it figures out that if there has been a violation of fundamental rights or rights that is taking place, the court can itself take suo motu cognizance of that particular matter and interfere and can issue writs. Suo motu भी कर सकती है कोर्ट, बहुत केसेस में किया है. But see, the problem with public interest litigation is that it's a very powerful tool evolved by judges of the Supreme Court like Justice V. Krishna Iyer. बेसिकली उनका ये कहना था कि भाई केवल कोई आदमी गरीब है या किसी रिमोट एरिया में रहता है या इलिटरेट है या उसके पास ज्यादा अंडरस्टैंडिंग नहीं है, उसको फंडामेंटल राइट नहीं डिनाई होना चाहिए, कोई और उसके बिहाफ पे अप्रोच कर ले. पब्लिक इंटरेस्ट के अंदर इफ देयर आर नंबर ऑफ पीपल हुज राइट्स आर गेटिंग वायलेटेड, then someone else can approach on their behalf to the court. But the problem is that vested interests have taken over the entire PIL regime in India. Many people file PIL either to become famous and therefore violating the entire objective of the PIL, or they are doing this in order to satisfy their personal interest. किसी एक बिजनेस हाउस के इंटरेस्ट को सेटिस्फाई करने के लिए दे विल अप्रोच द कोर्ट मेकिंग इट एज अ पब्लिक इंटरेस्ट लिटिगेशन. सो नंबर ऑफ टाइम्स प्राइवेट इंटरेस्ट इज डिस्गाइज्ड इन द फॉर्म ऑफ पब्लिक इंटरेस्ट एंड लिटिगेशन इज फाइल्ड इन फॉर्म ऑफ PIL by saying that sir please take an action because public interest is involved. Or at times people file frivolous PILs also in order to become famous. Because see, इंडिया के अंदर if you are a lawyer, you cannot solicit work. Bar council rules do not allow you to solicit work, advertise, and ask that आपका divorce का केस है आइए मेरे पास. You can't do that. Soliciting of work as a lawyer is not allowed in any way and in any form. ना WhatsApp पे, ना मेल पे, एड वैड आप कहीं नहीं देखोगे कि ऐसा तो नहीं लिखा होता कि आपकी अगर कोई समस्या है शादी के अंदर, डाउरी का केस है, कुछ है तो मेरे पास आइए. यू कांट सॉलिसिट वर्क. सो व्हाट अ लॉट ऑफ लॉयर्स हैव स्टार्टेड टू डू इज कि उल्टी सीधी PIL फाइल कर दो, और न्यूज चैनल्स वालों के पास तो वैसे ही काम है नहीं ज्यादा, सो दे विल पिक इट अप एंड फिर देन यू कैन बिकम फेमस. लास्ट ईयर देयर वाज अ PIL दैट वाज फाइल्ड बाय अ कपल. देयर वाज अ डॉक्टर कपल विच वाज देयर. अब आप सोचिए डॉक्टर्स का हाल है इस देश में. दे फाइल्ड द PIL. उन्होंने एक कोरोना माता मंदिर बनाया था. सोचिए आप, कोरोना माता मंदिर. सो दे मेड अ कोरोना माता मंदिर. और कोरोना माता मंदिर ये नहीं उन्होंने अपने घर में बनाया. देखिए इंडिया में क्या होता है कि पब्लिक लैंड को हड़पने का सबसे बेस्ट तरीका है कि आप वहां पे जाके मंदिर या मस्जिद या ऐसा कुछ बना दीजिए. उसके बाद फिर आप धर्म का झंडा उठा दीजिए, और फिर कोई कुछ बोले कि जी ये इलीगल कंस्ट्रक्शन है, प्रॉब्लम है, तो फिर आप बोलिए कि अरे हमारे रिलीजन पे अटैक हो रहा है. एंड सी दिस इज डन बाय एवरीवन, बिलीव मी. देयर आर सो मेनी केसेस वेयर पब्लिक लैंड हैज बीन इलीगली ऑक्युपाइड बाय पीपल in the name of religion by constructing a temple or a mosque or a church or this or that or XYZ. पब्लिक लैंड हड़पने का बेस्ट तरीका है आप सड़क पे जाके बना दीजिए अभी मंदिर. यहां पे मैं आपको दिखा सकता हूं. देयर आर यहीं पे इसी विसिनिटी में ही इलीगल कंस्ट्रक्शंस हैं जो कि पब्लिक लैंड सड़क के ऊपर बीच में मंदिर खड़ा कर दिया है विदाउट having any this thing. और उसके बाद क्या है फिर? then you can't demolish it. You can't demolish it. आप उसके साथ में घर भी खड़ा कर दीजिए अपना. Land is yours. That's how vested interests work in this society. And people, because they are so foolish, in the name of religion, they can go to any extent. So people will come down on the streets, will protest that our right to religion is being taken away. We are not being allowed to worship this, that, whatever, blah, blah. So they made this Corona Mata Mandir. Orders were given for demolition of this structure. Now they approached the court taking a PIL that saying that see we did it for public interest. So court first and foremost imposed a heavy penalty on this couple. Because they said you can't be wasting my time by unnecessarily coming with this litigation and calling it as a PIL. There is no public interest that is involved. This is an illegal construction. It has to be demolished. You can't be occupying public space like that. Whether it is Corona Mata Mandir or whatever it is. Right? And secondly, you are wasting the time of the court by filing such litigation and calling it as public interest litigation where your private interest is involved. There is no public interest involved in this. A few years earlier, there was one image of Mahendra Singh Dhoni which came on the Week magazine where, you know, he was depicted as Lord Vishnu or something like that. अब वो डिपेक्ट भी नहीं किया था उन्होंने, बस एक ऐसा गॉड डिपेक्ट किया था जिसके कि मल्टीपल हाथ हैं और एक हाथ में सोप है, एक हाथ में शैम्पू है, एक हाथ में कुछ है, यू नो, शोइंग दैट द काइंड ऑफ एडवर्टाइजिंग एंड ऑल ऑफ दैट इज टेकिंग प्लेस. तो इसके ऊपर एक आदमी चला गया दैट माय रिलीजियस सेंटिमेंट्स हैव बीन हर्ट, Dhoni has been depicted as a god. Again court imposed a penalty on this person. And ऐसे बहुत सारे लोगों को बार भी कर दिया जाता है कि you cannot file a petition now for next 2 years. Wasting of the time of the court. Trying to become famous. News channels picked it up. And then prime time debate is taking place. See, reality can be stranger than fiction, believe me. इस देश में हमें ह्यूमर की जरूरत नहीं है, नया कॉमेडी बनाने की जरूरत नहीं है, कंटेंट रोज डेवलप होता है. यही है सच्चाई ना. That's how things are. It's a very, very weird kind of a situation. So, these kind of instances are becoming more and more in number, and the problem is that the courts are already overburdened. You overburden them with these frivolous PILs, wasting the time of the court. You are denying justice to someone else because of these PILs being listed. So now the courts have created committees where a PIL will be considered only when it is scrutinized by the committee and it has been approved. And if the court finds that there has been any frivolous PIL that has been filed, then it can impose a penalty as well as take strict action against the petitioner for wasting the precious time of the court. So this is what we need to understand by PIL, and there are more, you can read more about the PIL and the kind of PILs, etc., that have been given importance or have been very important public interest litigations that have come up in front of Supreme Court of India in your value added material. For example, Vishakha versus State of Rajasthan. A woman approaches the court, she says that I have been sexually harassed at workplace. And this case should be treated differently. Because my boss was sexually harassing me. He was in a position of superiority. मैं कुछ बोलती भी तो I would have been fired from the job. So I was caught in a catch-22 situation. The court realized that there are no laws which are there in the country for preventing sexual harassment of women at workplaces. Because person is in a position of superiority, आप कुछ कह भी नहीं सकते. You are scared for your livelihood as well. So the person is exploiting you. So the court laid down guidelines that should be followed as rules, as laws, till the time Parliament enacts a law on sexual harassment. अब आप सोचिए 1997 के अंदर ये judgment आया, and 2013 is when Parliament of India enacted a law on prevention of sexual harassment at workplaces. It took so long for Parliament of India to get awakened, and that too, this all happened after Nirbhaya rape case, when the Justice Verma committee had been formed, and they recommended that there should be changes that should be made and a law should be introduced for prevention of sexual harassment. Because उस समय अचानक से this entire debate on women's safety and sexual assault, rape, etc. started to take place in the Indian society, because it was such an incident that shook the entire society from within, that something like this can happen and this is happening. And see, unfortunately, in this country, sexual assault cases are happening on a daily basis. Unfortunately, they are just not being reported. Anyway, so Vishakha case, then Vineet Narayan versus Union of India, where a former journalist approaches the Supreme Court that the CBI is not acting in a free, fair and independent manner. CVC is not functioning properly. Cases of corruption against the public servants are not being heard properly, so you please intervene into this matter. Husainara Khatun versus State of Bihar, where the petitioner approached the court on the behalf of the under trial prisoners in Bihar, that they are being subjugated to a number of atrocities. The inhumane conditions in which these inmates of the prisons have been put in, despite not being convicts. So Justice B.N. Bhagwati in this case issues the release of 40,000 prisoners from across the country, those who are under trials. So there have been several cases of PIL which have been very, very important, where the Supreme Court has tried to do away with the principle of locus standi in order to ensure the enforcement of the fundamental rights in public interest. But there are, of course, concerns that are associated with how the PIL regime operates in India. There are vested interests. Some people, court itself has noted a number of times that PIL has turned into private interest litigation in this country. There is a whole PIL industry that is running. कुछ lawyers ने अपना career पूरा जो है वो PIL file कर करके बना लिया है. And then, of course, the biggest problem is that it is denying justice to the rightful person when the PILs are being filed in such a manner, and already there is an increased burden on the court. Frivolous PILs being filed, number of PILs are going up, which is increasing the workload for the court. Right? So UPSC may ask you, what do you understand by public interest litigation? And then it may ask you to critically analyze the public interest litigation regime. So some of the points that have been mentioned here in the slide can be used by you for that particular purpose. Significance of PIL as well as the concerns that are arising out of PILs. First is that it democratizes, some people believe that it democratizes access to justice. Now even the poorest of the poor can get access to justice, even though they may not have means to approach the court through the PIL regime, right? Also, it is an instrument of social change as well, that now the weak and the marginalized can get justice, which they were not able to get earlier. It ensures effective enforcement of the fundamental rights. Then it is a tool to enforce the rule of law in the country, and it strengthens the power of judicial review as well, because judiciary can now keep a check on the actions of the executive and the legislature even when the aggrieved party is not approaching the court, if it is in the larger public interest. And then it has improved the public participation, again democratizing the access to justice in the country, and it has helped in judicial monitoring of the institutions in the country. But there are certain concerns also associated with PIL. First and foremost, it has increased the workload on the Supreme Court, which is already overburdened, and therefore further increasing the pendency of cases in the court. Secondly, a lot of people say that, see, people approach the court that the PIL regime is used to say that, you know, the government has not done this or the government has not done that. But PIL cannot be a substitute for bad governance. The answer to bad governance is to throw out those people, those who are not governing properly, and to get the alternate people into power. Not that you approach the court for everything and say that the government is not functioning properly. If government is not functioning properly, it's democracy, you throw them out of power. Because if the courts start interfering in the area of the administration, then tomorrow administration or executive will also start interfering into the area of the courts by saying that 4 crore cases are pending, let us also interfere in this matter. So it can be a dual sword kind of a problem. Supreme Court has no administrative experience. They cannot be issuing order to the executive ki 8 se 10 baje ke beech mein patake bajenge. See, enforcement of this is also a challenge, no? Court cannot be just issuing orders which it thinks is correct. अपने whims and fancies पे नहीं कह सकते. One day you realize that there are too many droughts in the country, too many floods in the country, let us interlink all the rivers in the country. This is interfering into the domain of the executive, leading to violation of separation of powers. So just because there is bad governance that is taking place, you cannot approach every time to the court and ask that, sir, please interfere and issue a writ of mandamus in public interest. आप नहीं कर सकते, क्योंकि फिर इसका excessive use होना शुरू हो जाएगा. Violation of principles of separation of powers, disturbing the delicate balance that has been created between the various institutions of the state in India. Then PILs may lead to policy paralysis as well. What does that mean? If every time you start approaching against the executive and the administration to the court stating that, sir, mandamus की writ issue कर दीजिए, इन्होंने काम नहीं किया है, या सरसोरारी issue कर दीजिए, इन्होंने ऐसा किया है, तो people will stop taking decisions. A policy paralysis will develop. See, in public policy, administrative authorities do not necessarily have the benefit of hindsight. उनको नहीं पता होता कि ये policy जरूरी नहीं है कि काम करे कि नहीं करे. But if you start questioning the actions of the government and the executive on every matter where the policy has not resulted in the desired objectives, then it will create a policy paralysis. What happened in 2011-12? When number of corruption cases were coming across left, right and center, various senior civil servants stopped taking decisions because उनको realize हुआ कि यार ये 2G scam में कुछ लोगों को फंसा दिया है फालतू में. Some officers have also unnecessarily got involved in this entire controversy by stating कि आपने decision कैसे ले लिया first come first serve basis पे. अरे इसलिए ले लिया क्योंकि हमें नहीं पता था कि क्या 2G स्पेक्ट्रम का इतना अपटेक होगा कि नहीं होगा. भाई, as a policy maker, when you people will get into policy making, when you will be taking certain decisions, आपको जरूरी नहीं है पता हो कि इसका क्या desired effect ये अचीव कर पाएगा कि नहीं कर पाएगा. You are not Nostradamus that you can predict everything. Policy decisions can go wrong, and that's how policy making happens. परफेक्ट पॉलिसी मेकिंग तो कभी भी नहीं होती, किसी देश में नहीं होती. So if people start getting scared to take policy decisions for the want of interference of the judiciary, then it will lead to a policy paralysis and officers will stop taking decision altogether. The government will stop functioning completely. And then lastly, as I said, that the benefits of the PIL often are enjoyed by the rich and the powerful, therefore defeating the entire purpose of the PIL regime as well. ठीक है. So these are some points which can be mentioned by you to talk about the critical analysis or critical examination of the PIL regime in India. एक छोटा सा नोट लिख लीजिए इसके ऊपर on the PIL, right? And ये बाद में आप नोट कर लीजिएगा the strengths or the concerns which are associated with the PIL regime in India. Please write down. The Supreme Court innovated the concept of PIL. The Supreme Court innovated the concept of PIL where it may admit writ petitions as an exception to the principle of locus standi, by public spirited individuals. Full stop. The court has stated that public spirited individuals may move the court to further a social or public interest, where the court may relax the locus standi requirements. Full stop. In Husainara Khatun case, the plight of under trials in prisons in Bihar. In Husainara Khatun case, the plight of under trials in prisons in Bihar was brought to the notice of the Supreme Court. And a petition was filed asking for justice on the behalf of the under trials. Justice P.N. Bhagwati set aside the principle of locus standi and ordered the release of 40,000 prisoners from various jails across the country. The court held that The right to speedy trials and legal aid, the court held that the right to speedy trials and legal aid is an integral component of Article 21 and the court can use its extraordinary powers to ensure its enforcement. This case set precedent for several future cases as a result of which members of the public having sufficient public interest can approach the court for the enforcement of the fundamental rights of the weak and the marginalized. ठीक है? So this is all about Article 32 of the Indian Constitution. Any questions or any doubts? Now let's quickly also have a look at Article 33 and Article 34 of the Indian Constitution that are also part of Part 3 of the Indian Constitution, but they are exceptions to fundamental rights. Now Article 33 basically gives powers to the Parliament and only Parliament to make a law where it can restrict or abrogate the application of fundamental rights with respect to those people who are associated with the security forces and similar functions. So the members of the security forces, armed forces, do not have all the fundamental rights available to them, which can be curbed by a law made by the Parliament. For example, in India we have the Air Force Act or the Army Act or the Police Restriction of Rights Act, Police Forces Restriction of Rights Act. स्ट्रीमिंग चल रहा है? ओके, ठीक है, तुम्हें क्या, बैठो आराम से. So there is the Police Power Restriction of Rights Act, which have been enacted by the Parliament, as a result of which they have restricted the application of fundamental rights to the members of the armed forces, security forces, or those who are connected with the maintenance of law and order. The idea is because, see, when it comes to matter of national security, when it comes to matters of defense, then you can't have the expectation that the members of the armed forces would be demanding all the fundamental rights. तो उनके केसेस में fundamental rights को restrict किया जा सकता है. ये एक exception है fundamental rights के चैप्टर के लिए कि कुछ लोगों के fundamental rights उनके लिए restrict किए जा सकते हैं, but ये सबके लिए नहीं है. This is only for certain kind of forces which have been mentioned in Article 33. तो एक बार Article 33 देख लेते हैं. 33 says that Parliament may by law determine to what extent any of the rights conferred by this part shall in their application to A, B, C, D, E be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of discipline among them. और वो कौन से फोर्सेस हैं या कौन से ऐसे organizations हैं where fundamental rights can be restricted? One, the members of the armed forces. So as I was telling you, Parliament of India has enacted what is called as the Army Act. There are certain restrictions that have been provided in the Army Act of 1950 with respect to the fundamental rights that are available to the members of the army. Then we have the members of the forces charged with the maintenance of public order. तो ये कौन है? Police, right? So there is an act called as the police forces restriction of rights act, which has been made by the parliament under its powers of Article 33 of the Constitution. Then anyone who is employed in any bureau or organization established by the state for the purpose of intelligence or counter intelligence. तो इसमें आपके कितने सारे institutions आ जाएंगे? RAW, IB, NTRO, number of intelligence agencies will come under the ambit of this particular article. इन सब के members जो हैं, their fundamental rights can be restricted by a law made by the Parliament of India. And then we have persons employed or in connection with the telecommunication system set up for the purpose of any force, bureau or organization referred to in clause A to C. So if you are associated with the maintenance and the functioning of the telecommunication system that is used by any of such forces which have been mentioned, then in that case also your fundamental rights can be restricted. Is that clear? So that is very simple. Article 33 of the Constitution. अगर आप इसका कैप्शन भी पढ़ेंगे तो आपको समझ में आ जाएगा. Power of the Parliament to modify the rights conferred by this part in their application to forces, etc. This power is only available to the Parliament of India to make an exception for the application of fundamental rights. Is that clear? So please write down quickly related to Article 33. Article 33 is an exception. To the chapter of fundamental rights. Is an exception to fundamental rights. Is an exception to fundamental rights, where Parliament has been provided powers. Where Parliament has been provided powers to make a law, to decide if the fundamental rights, would be available fully, to decide if the fundamental rights would be available fully or with modifications, or not at all, to the members of security forces, and the likes of them, The idea behind this article is to ensure maintenance of discipline is to ensure maintenance of discipline in such forces, is to ensure maintenance of discipline in such forces and to allow them to discharge their duties and to allow them to discharge their duties properly. ठीक है. और देखिए जब भी आप नोट्स बनाएं तो ना एक्रोनिम्स यूज कर लीजिए, शॉर्ट टर्म्स यूज कर लीजिए, सो दैट नोट्स में तो कोई दिक्कत नहीं है, आंसर में मत लिख के आइएगा बस, है ना. डोंट राइट एक्रोनिम्स और शॉर्ट टर्म्स देयर. हियर गवर्नमेंट यू कैन राइट जीओवीटी, गवर्नर यू कैन राइट जीओवी एक्सेट्रा, बट यू शुड नो. ऐसा नहीं कि आपने गवर्नर लिख लिया और फिर आप बाद में उसको गवर्नमेंट पढ़ रहे हो. भी रिसेंटली आई हैड गॉन टू राजस्थान झुंझुनू एंड वहां पे मैं रास्ते में जा रहा था तो मेरे को ना एक रेस्टोरेंट दिखा, भूख लग रही थी बड़ी, तो क्या वहां पे रास्ते में रेस्टोरेंट था एक, उसका नाम था यूपीएससी तड़का. मैं वही ढंग का थोड़ा कुछ दिख रहा था तो हम रुक गए वहां पे. पूछा भाई अच्छा क्या है, मैंने उससे फिर ओनर से पूछा, मैंने बोला यार यूपीएससी क्यों रखा है तुमने अपना. तो वो मेरे को बोलता कि नहीं इसका मतलब तो अल्टीमेट पंजाबी साउथ इंडियन चाइनीज है. आई एम नॉट किडिंग, आई एम नॉट लाइंग, आप चेक कीजिएगा कभी. यूपीएससी तड़का करके रेस्टोरेंट बना हुआ हाईवे के ऊपर, ठीक है. बोलता है अल्टीमेट पंजाबी साउथ इंडियन. मैंने, मेरा दिमाग एकदम मतलब खराब हो गया. मैंने बोला यार ये क्या है मतलब, तो ऐसे एक्रोनिम्स मत बनाइएगा. Other than that, everything is okay. Anyway, so this is 33. Now 34 of the Constitution. तुम भी वैसे अच्छा आइडिया है ये. रेस्टोरेंट सेटअप करना हो तुम्हें बाद में कभी तो ठीक है. यहाँ पे वैसे बड़े मैंने देखा यार, एक कोई फॉर्मर एस्पिरेंट मिल गया तो वो उसने मोमो के ठेले सेटअप करवा लिए 3-4. मजाक, आई एम नॉट किडिंग भाई. मार्केट तो आपको पता ही है यहाँ पे पूरा सब, और चाय की भी पता है एस्पिरेंट्स की. अब नहीं हुआ सिलेक्शन तो कुछ तो करोगे जिंदगी में, और बुरा नहीं है यार, आप ऐसे मत सोचो इसको. उसने 3-4 जो भी है ये सब लड़के हायर किए और अपना मोमो का मस्त काम चल रहा है उसका. और देखिए अच्छी बात ये है, कल मेरे को कोई बोल रहा था, मतलब मैं फ्रेंड जी को सेइंग कि यार हम इतना टैक्स देते हैं, ये बिजनेसमैन को टैक्स भी देने की जरूरत नहीं है, राइट. अंडर वॉइसिंग करते रहो, कोई दिक्कत नहीं है. छोले भटूरे जो बेच रहा है वो मतलब वो काफी ज्यादा लोगों से बहुत ज्यादा पैसे कमा रहा है, पता है आपको. छोले कुलचे का ठेला लगाने वाला भी, क्योंकि उसको टैक्स तो देना नहीं पड़ रहा, सारा वही टैक्सेबल इनकम है ही नहीं उसका. ही कैन जस्ट शो कि मेरे तो 2 लाख रुपए की कमाई होती है. कैसे प्रूव करेगा कोई, राइट. एनीवे, सो नाउ आर्टिकल 34 ऑफ द कॉन्स्टिट्यूशन. आर्टिकल 34 इज ऑल्सो एन एक्सेप्शन टू the chapter of fundamental rights. See, ideally if someone's fundamental rights are taken away, then the provision should be that one can approach the court, etc., and so on and so forth. But also there is a principle of equality in the Indian constitution, but article 34 is an exception to that, which is saying that notwithstanding anything in the foregoing provisions of this part, Parliament may by law, Parliament may by law indemnify any person in the service of the Union or of a state or any other person in respect of any act done by him in connection with the maintenance or restoration of order in any area within the territory of India where the martial law was in force. Basically, first and foremost, try to understand what is the meaning of indemnification. Indemnification is to take away a person's legal liability for an act of omission or commission. Basically, एक immunity है ये. Indemnification means that you are given an immunity against a legal trial. अब आर्टिकल 14 हमने पढ़ा है, which says that everyone is equal in the eyes of the law, but in those areas where martial law is in force, मार्शल लॉ का कोई स्पेसिफिक डेफिनेशन नहीं है. मार्शल लॉ बेसिकली मीन्स वेयर द रूल ऑफ द आर्मी इज देयर. Civilian administration has given control to the army or the military to take over the administration of that area. So in an area where martial law is in force, in those areas, Parliament can make a law and provide indemnity, or that is provide immunity against legal action against a person who is in the service of the state or the union or otherwise who is given the power or the duty of restoration of law and order in that area. One example is AFSPA, Armed Forces. Please do, be very careful right now. The number of COVID cases are increasing rapidly. Maybe you may not, it may not be as fatal as it was last year, but it can waste your time. You people do not have so much time. 4-5 दिन तबीयत खराब हो जाएगी, then you will be in bed and then it will take time to recover and all of that. You will be unnecessarily facing cold, cough, etc. and all of those things, running nose. So it's better that you take precautions. Okay. I know it's very frustrating and difficult to to take precautions right now, especially when after having gone through all of this, but be careful about this. Okay. ये streaming चल रहा है नहीं? चल रहा है? But okay. So Article 34 of the Indian Constitution provides powers to the Parliament to make a law by which it can indemnify the acts of a person who is in the service of the state or the union or otherwise who has been given the responsibility of maintenance of law and order or restoration of law and order in an area where martial law is in force. Armed Forces Special Powers Act of 1958 provides immunity to the members of the armed forces which have been declared as disturbed areas and where AFSPA is in force. एक तो उनके पास extraordinary powers हैं कि वो search, seizure, arrest कर सकते हैं without a warrant in areas where AFSPA is in force. But more importantly, they have been given immunity as well. For example, if a person who is in the armed forces where AFSPA is in force is alleged to have violated fundamental rights or human rights of some person, an inquiry cannot be initiated against that person. A complaint cannot be registered against that person in the police station until and unless there is an approval that is given by the central government. So this is in order to give a special position to the armed forces in those areas where the law and order is not functioning properly, जहां पे मार्शल लॉ इज इन फोर्स. अब मार्शल लॉ का कोई स्पेसिफिक डेफिनेशन नहीं है. ये कहा जाता है कि दोज एरियाज विच आर कॉन्फ्लिक्ट एरियाज वेयर द नॉर्मल एडमिनिस्ट्रेशन हैज बीन टेकन ओवर बाय द मिलिट्री और बाय द सिक्योरिटी फोर्सेस. दैट इज व्हाट इज कॉल्ड एज मार्शल लॉ, बट कोई स्पेसिफिक डेफिनेशन नहीं है इंडियन कॉन्स्टिट्यूशन में. AFSPA is one such law which has been enacted by the Parliament of India that provides indemnification to the acts of the members of the Central Armed Police Forces and the armed forces which are posted in those areas which have been declared as disturbed areas under the AFSPA Act. Is that clear to everyone? So please write down quickly related to 34. It provides Parliament the powers. रुकना पड़ेगा. नहीं ठीक है, कोई नहीं. Article 34 you have understood, right? And I hope that's I'll just explain it again. Okay, note you can do it later, and probably online students, if there is a problem, once I give the notes, then it will become very clear, right? Simple thing. Parliament can make a law to indemnify the acts of an individual who is connected with the security forces or with some kind of a authority which has been given powers to restore the law and order in an area where martial law is in force. There is no specific definition of martial law as per the Indian Constitution or otherwise, but what martial law basically means is those areas where the normal rule of the civilian administration has been replaced by the control of the military and the armed forces. That is what is called as martial law. Is that clear? Right? Any questions or any doubts? So, अच्छा screen भी बंद हो गई. Anyway, so yeah, that's pretty much about it for today. We have a class tomorrow, right? So my परसों होगी, sorry, है ना? Thursday को होगी. Friday को है, अच्छा, sorry. So please ensure that before you turn up for the next class, जो DPSPs हैं सारे वो आप पढ़ के आइएगा. इनफैक्ट माय सजेशन विल बी या तो वैल्यू एडेड मटेरियल या एम लक्ष्मीकांत, कोई भी एक जगह से DPSP का पूरा टॉपिक पढ़ के आइएगा पहले बिफोर यू टर्न अप फॉर द क्लास, बिकॉज आई डोंट वांट टू बी वेस्टिंग टाइम ऑन डिस्कसिंग द फैक्चुअल थिंग्स इन द DPSPs. दे आर वेरी सिंपल एंड स्ट्रेट फॉरवर्ड. वी कैन स्किप ओवर टू द पार्ट विच रिक्वायर्स मोर एनालिसिस एंड डिस्कशन. ओके, सो प्लीज डू दैट बिफोर यू टर्न अप फॉर द नेक्स्ट क्लास. और आर्टिकल 34 का जो इशू है, यू नो सम बिकॉज अभी ये कुछ पावर कट हो गया था एंड ऑल ऑफ दैट, सो आई विल डिक्टेट यू नोट्स ऑन फ्राइडे रिलेटेड टू आर्टिकल 34 एंड दैट शुड बी एनफ, राइट? विद दिस वी विल एंड द चैप्टर ऑफ फंडामेंटल राइट्स. ऑफ कोर्स एज आर सर रिमाइंडेड मी कि सर 31 का क्या, पहली बात तो 31 इज नॉट देयर. 31A, 31B, 31C इज देयर. We'll discuss about it when we discuss the right to property. जब fundamental rights का chapter खत्म हो जाएगा, DPSPs खत्म हो जाएगा, then we will take up the 31A, 31B and 31C. Okay? I'll see you on Friday. Thank you so much.